And based upon the content of this program, we wish effectively to be able to identify some HIPAA basics for patient records. Hopefully none of those are a surprise and we will know those things. We go over a little bit about the privacy exceptions with patient consent. We'll also talk about privacy exceptions for law enforcement purposes of a civil nature and for law enforcement purposes of a criminal nature, and how exceptions to HIPAA privacy are applied by law enforcement agencies, with an emphasis there on state licensure boards and agencies. You know, not everyone in the public can just show up like a newspaper reporter or a patient's member of the family or what have you and say, hey, I'd like all the dental records on this patient. But state agencies and federal agencies can. How do they do that? Why do they do that? And what do you need to know when you are in trouble? Not to get ahead of ourselves, but you know, there's certainly two kinds of ways that you might be involved. You might be the target of an investigation for fraud or misconduct, and the licensure police come looking for you and your patient records. You may have nothing to do with that, and some other healthcare professional is the target. Why? You were the subsequent treating professional. It was common for a patient to go to dentist number 1, get a botched root canal or something, and go to dentist number 2 to fix it. And so how does HIPAA apply when you've done nothing wrong? You simply were dentist number 2 that had to show up and fix it. Let's move on to the next slide, please, now. Okay, thank you. Slide 8. Yes, we'll stay on slide 8. So based upon the content of this program, we want to be able to effectively show you how you can comply with a request for protected health information when the patient is in trouble and law enforcement is involved, how you may comply when you are in trouble and law enforcement is involved. And we talk a little bit about case law from the courts regarding HIPAA privacy exceptions for law enforcement. You know, really, when I updated this, there was not much new to learn from case law. It's because of the preliminary nature of how law enforcement operates, so I think we're just going to skip this on any instructive law from the courts. Just think about the investigative process as being preliminary, where the state is going to get records using a HIPAA exception. They may get them from some other practitioner or have some other avenue to get them, and an investigation continues. That train chugs down the track, and you don't usually have a stand and fight type issue over HIPAA compliance and records in those kinds of situations where that's just an early step in an ongoing investigation. So let's move on now to the next, please. Let's move 9, please. Again, let's talk about what this does and does not cover. I want everybody to be on the same page so that we know what we're getting into and what you expect here. This does provide a broad overview of HIPAA confidentiality issues. It does not cover everything about HIPAA or HIPAA as applied to any specific healthcare profession. And it does educate all you people attending, all you persons, to ask the right questions in your own jurisdiction, your own state, your own healthcare facility, if that's where you work, and profession about compliance with HIPAA confidentiality and the law enforcement exceptions in any given situation. So we'll move on now to 10. Again, it does not cover all the HIPAA exceptions as they relate to law enforcement, but the ones that might be more applicable to healthcare practitioners in general. It does educate you to ask the right questions. You may seek out a HIPAA checklist. It does educate the person to know law enforcement exceptions are very fact-specific and very narrow. Don't ever let the police tell you that I'm the police and with whatever this or whatever that, we can get anything we want for any reason. That is not the case. You might think that the police with a piece of paper know more than you do as a dentist or healthcare professional about what the police can and cannot get, but that is not necessarily the case. We'll first start with some basics of HIPAA requirements for patient records. Hopefully, we all know this, so I'll be brief with it. We all know that it created a federal right of privacy in healthcare records and protected health information. But there were, before that, and there still exists, a smattering of state law privacy rights. Also, medical confidentiality as found in state licensure laws, especially in mental health laws, less so, for example, in physical medicine like physical therapy. There is a state administrative regulation, which has the force of law like a statute, in my home jurisdiction here that applies to psychologists, it has 13 different subparts just on patient confidentiality. The do's and do nots, the 10 commandments of patient confidentiality for psychologists isn't even 10 in number, it's 13. I guess the 13 commandments doesn't have much of a ring to it. But there's much less of that detail in physical medicine, such as physical therapy. You do have medical confidentiality also found in national and state codes of ethics. Those are usually non-binding. The local medical society is nothing more than a country club for doctors who share an interest in medicine, and they may have a society code of ethics, but that is not the law. It's a courtesy code and a politeness code, and violating it is not violating the law. There are some exceptions to that that are very, very narrow that I won't go into. Some of that is the subject of some of my other presentations on healthcare and licensure law, and you can look for those on Compliance IQ. You also have state rules of evidence for privileged communications. Those rules of evidence, federal and state rules of evidence, would have, again, specific elements. The things you tell your doctor are confidential with limitations within the patient-doctor relationship. If you're out in a golf foursome with your rabbi and your two dentist friends, and you blurt out something, what you tell, just because your physician is present, it doesn't mean that that is confidential, especially not with third parties present, and also not with an expectation of privacy because you're not obviously on the golf course getting medical treatment. HIPAA was effective in about April 2013 with the final regulations. As we know, it applied to healthcare providers who submitted payment requests via electronic means. Protected health information is for covered entities. It covers independent contractors as well who are business associates. For us lawyers, that can include law firms who hold medical records as protected health information. So you have to meet the same standards generally of a medical provider if you are a business associate, a law firm, for example, that maintains patient records or any kind of protected health information in the course of their legal work. Protected health information is any information held by a covered entity that concerns the health status, the provision of health care, or payment for health care that can be linked to an individual. Interpreted rather broadly is to include any part of an individual's medical record or payment history. Now, a side issue, there are social media posts which can violate HIPAA privacy and state privacy laws if the information can be linked to an individual. Privacy can still be violated even if other information is released. That is the subject of tomorrow's webinar that I will be doing for Compliance IQ called Fired by Facebook. I mention that because I was just at an ethics CLE last Thursday in Louisville, and the presenter was talking about confidentiality with lawyers and how lawyers might post on their social media, had a really tough day in court today, Friday, with that gruesome murder trial. I can't believe the witness did this or the witness did that, when in fact that may be a confidentiality issue because in a small town in Kentucky, there was only one murder trial going on, and the people may be able to very easily link who that statement is about. So likewise, social media is a pitfall when a nurse writes on her Facebook page, terrible car crash tonight in small town Kentucky, what a gruesome night at the ER, that may violate HIPAA. If you want to really be entertained even more than this one, please attend tomorrow. So more on the basics of HIPAA requirements for patient records. There are many exceptions for law enforcement officials to obtain records for law enforcement purposes as required by law. Now we're getting into the meat of the exceptions for law enforcement purposes. You have court orders, court-ordered warrants, subpoenas, and administrative requests like administrative subpoenas for state agencies involved in investigations, or to identify or locate a suspect, fugitive, material witness, or missing person. So think about this, court orders, court-ordered warrants, and subpoenas, or that comes from the criminal people. That would be done with served by a detective in a uniform or with a badge, or maybe Maybe by law enforcement, you know, in a blue uniform with a policeman's cap on and a badge. You have administrative agencies, administrative subpoenas served by state investigators. Those can be done for a variety of purposes, like, again, locate a suspect, fugitive, material witness, or missing person. Think about the differences there. If you're a dentist and the police knock on your door and they say, we're here to locate a suspect or a fugitive or material witness or a missing person, we need their protected health information, home address, when they were last in town for treatment, maybe their social security number, weight, height, whatever they might need to track somebody down. But the question then is, am I a suspect in the missing person being gone? Or are you looking, oh no, we think this person was kidnapped at a bank robbery and has nothing to do with the practice of your profession. So that's a situation where the dentist should gladly want to help locate a fugitive, material witness, or missing person. You know, except for the above, the covered entity may not disclose protected health information without the written consent of the patient. Written consent is required, or notification of the patient, and sufficient time to object. So you really do need to know that you don't need patient consent for that the police have these various exceptions that they can utilize. You know, most of this was not new to mental health practitioner. There are lots of continuing education on HIPAA and its changes. You know, medical practitioners, or rather mental health practitioners, were very, very well versed in not talking about their cases with their colleagues over lunch, not speaking about them in the elevator at the clinic. You never know whose patient or family member might be in the same elevator with you. So this was not new to mental health professionals and practitioners to have this kind of level of sanctity of protected health information. Obviously, individual patient rights are there to limit the release of protected health information. For example, you can designate to your doctor or dentist or whomever, I only want to be called at my work phone, don't call me at my home phone, and those kind of patient rights are to be provided in writing. So with reference to medical record keeping standards, let's say that, you know, this is before the police come knocking at your door. What about HIPAA applies to keeping medical records in the first place? The federal law of HIPAA does not govern the length of time medical records of healthcare providers are kept. That is governed by individual state law, which we have explored. It involves each profession and in each state. It's not the same from profession to profession, certainly not the same from state to state. And again, a lot of these nuggets of information could stand on their own, and this is another webinar that I've done, including for Compliance IQ, about retention of medical records. But the many, many times I heard practitioners say, oh, well, HIPAA tells you how long you need to keep the records. No, it does not. It's even in their FAQ. You have to defer to state law. So if you're a dentist in California, you need to know what record-keeping requirements are mandated by the dental laws of the state of California, and that is not the same for every dentist, and that is not the same from state to state. HIPAA tells you how to keep it confidential, how to release it and why, and does not require you to keep it for any specified period of time. It's just that so long as you have that period of time, you got to keep it confidential and only release it as such. So with patient consent, there's implied consent, of course, things like, yes, of course you want your dentist to file for insurance for that root canal, billings and other things like that. Express consent, any reason or for no reason, if the patient wants it. Consent can be delegated, such as providing records to the attorney of the patient. If the patient consents, their attorney can get a record of that, and you may not know why they want the attorney to have a record of it. That can be for any reason or for no reason, simply other than the patient wants it. And consent can be delegated, you know, to third parties, like I want my attorney to have these records. What else can I say about express consent here? Again, it can be for any reason or for no reason, and that is part of the HIPAA requirement. By the way, short note here, mental health professionals have to provide a right, have to fulfill the patient's right to get a copy of their records. There is no exception for I can't give a patient a copy of their own records because they might be embarrassed by it or they might be offended or take something out of context. And again, that's a whole other sub-issue of mental health law and record keeping. But the basic idea is that with the express consent of the patient, any reason or for no reason other than the patient wants it, you got to give a copy of your records. There are exceptions usually found in mental health, such as treating a minor in a mental health treatment whose parents are involved in a contested child custody matter. That may require court permission or a guardian ad litem's approval or what have you. There's just no exception to withhold records for the, quote, well-being of the patient. And how mental health professionals carry that out is kind of slick, and that is the topic for another day and time. There are unique HIPAA releases for drug and alcohol treatment centers. Just use their own release of records authorization form. A general HIPAA release that would be good for any healthcare provider, a dentist, a physical therapist, a medical office, is not good for those. HIPAA exceptions for law enforcement. This comes under the uses and disclosures of for which an authorization opportunity to agree or to object is not required. Of course it's not required. The police are trying to track down a fugitive from justice, and they need the person's maybe last known address, maybe they had some significant work done recently medically, and they're not going to consent. They're on the run from the law. But there are still restrictions with those. I have labeled these that we will talk about today as the exceptions, quote, for law enforcement purposes. They could be for all kinds of purposes. Law enforcement as a term can be broadly applied to the government. This is not simply a criminal setting. So let's zip through and hit the highlights of some of the most applicable ones that might be here for you. A public health authority that is authorized by law to collect or receive information for the purposes of preventing or controlling disease, injury, disability, including but not limited to the reporting of disease, injury, vital statistics such as birth or death, and the conduct of public health surveillance, public health investigations, and public health interventions, or at the direction of a public health authority to an official of a foreign government agency that is acting in collaboration with a public authority. How do you think we got information about those Ebola patients who were airlifted back to the United States? Volunteer workers, nurses, doctors who contracted Ebola, did they have to consent to that? No. You also have the health department, local health departments, which may be in charge of epidemiological investigations, tracking down food or other sexually transmitted diseases, for example, and they have a right to certain information under authority of law for public health information. Those are ones where, you as the dentist or the physician or physical therapist are not the target of that. They're worried about transmission of diseases, et cetera, and they're not necessarily saying, and you're the ones that transmitted it. They're trying to track down the patient. Public health activities also include a public health authority or other appropriate government authority authorized by law to receive reports of child abuse or neglect, often a mandatory duty under state law. In Kentucky, any person, are you a person? If you're a person, this applies to you. Any person in Kentucky who has reasonable cause to believe, not knows, not beyond a shadow of a doubt, not beyond clear and convincing reasons, but reason to believe has a duty to report child abuse or neglect to the appropriate authorities. The exceptions to that include the priest-penitent privilege and lawyer-client privilege. Also, a person who is subject to the jurisdiction of the Food and Drug Administration with respect to an FDA-regulated product or activity for which that person has responsibility for the purposes of the activities related to the quality, safety, or effectiveness of the FDA-related product or activity. So see how limited that is? As a dentist or a physical therapist or a medical provider, you're probably not a person subject to the jurisdiction of the Food and Drug Administration, except for those products and such that are regulated by the FDA. So a person who is subject to the FDA with respect to the FDA regular activity has a narrow purpose, including to collect or report adverse events or similar activities with respect to food or dietary supplements, product defects or problems, including problems of the use of labeling a product or biological product deviations, to track FDA-regulated product, to enable product recalls, repairs, or replacements, or look-backs, including locating and notifying individuals who have received products that have been recalled, withdrawn, or the subject of look-back, or to conduct post-marketing surveillance. You might have bad hip replacements out there, and the appropriate authorities are trying to track down all of the people who have had a hip replacement from a certain factory, a certain provider, or what have you, and they are allowed to do so and get HIPAA records. So remember, the person with a possibly bad or defective hip transplant would want the FDA-authorized people to get that information, and they do not require the patient consent for that. So more public health activity exceptions, including a person who may have been exposed to a communicable disease, I mentioned Ebola earlier, or may otherwise be at the risk of contracting or spreading a disease or condition if the covered entity or public health authority is authorized by law to notify such person as necessary in the conduct of a public health intervention or investigation. We also have employers who meet a healthcare exception. Although that is not typically law enforcement, it does relate to government oversight like occupational health, safety and health regulations and such. So an employer can get information about an individual who is a member of the workforce of the employer if the covered entity is a covered healthcare provider who provides healthcare to the individual at the request of the employer. So you might have an on-site medical clinic at a big factory, and there's a HIPAA exception for what goes on there. Or if an employer is conducting an evaluation relating to medical surveillance of the workplace, or to evaluate whether an individual has a work-related illness or injury, where the protected health information that is disclosed consists of findings concerning a work-related illness or injury or a workplace-related medical surveillance. The employer also may need such findings in order to comply with its own obligations under applicable codified regulations or under state law having a similar purpose to record such illness or injury to carry out the responsibilities for workplace medical surveillance, and where the covered healthcare provider provides written notice to the individual that protected health information relating to the medical surveillance of the workplace and work-related illnesses and injury is disclosed to the employer, and there are many, many further requirements. These are the kinds of things you see on the wall of a large business office or a factory. Notice we pay minimum wage. Notice we comply with occupational health and safety requirements. Notice we may request and collect protected health information as a covered health care provider as an employer for workforce purposes. So trying to gauge our time now so that we're at least halfway through. Other public health activities involve not employers but school. Lots of people work at schools or children attend schools. These are things about an individual who is a student or prospective student of the school if the protected health information that is disclosed is limited to proof of immunization. That's how schools can authorize to get and keep your kids' immunization records, where the school is required by the state or other law to have such proof of immunization prior to admitting the individual. Also, the covered entity obtains and documents the agreement to the disclosure either from a parent, guardian, or other person acting in loco parentis. Didn't know you were going to hear Latin today. Didn't know I knew Latin. In loco parentis of the individual, if the individual is an unemancipated minor. You also have the issue of whether the individual, if the individual is an adult or an emancipated minor. So there's a little bit about schools are not exactly law enforcement maybe. Maybe this webinar needs a better title, but certainly the schools serve a government function. We also have a little hard to read on this, but it's important to know this is about disclosure about victims of abuse, neglect, or domestic violence. These are permitted disclosures. They are not required except for reports of child abuse or neglect that are provided as mandated by state law. A covered entity may disclose protected health information about an individual whom the covered entity reasonably believes to be a victim of abuse, neglect, or domestic violence to a government authority, including a social service or protective services agency authorized by law to receive reports of such abuse, neglect, or domestic violence. It's too much to go into about like my state's requirements on domestic violence or the abuse or neglect or exploitation of vulnerable adults. Not any adult, but vulnerable adults who cannot otherwise appropriately defend themselves. To the extent that the disclosure is required by law and the disclosure complies with and is limited to the relevant requirements of such law. So again, just like in my home state here, there's a duty to report suspected child abuse, neglect, or dependency. You have a duty to report exploitation, abuse, or neglect of a vulnerable adult, where that disclosure complies with and is limited to the relevant requirements of such law. Or if the individual agrees to the disclosure, or to the extent the disclosure is expressly authorized by statute or regulation. This is a good time to jump in there, and not to belabor child abuse or adult abuse or neglect, but remember I said in my home state there's a general duty to report reasonable cause to believe there has been abuse or neglect or a dependency of a child. You also have a separate section that says if the person who is reporting this is a physician, nurse, dentist, physical therapist, chiropractor, blah, 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 any one of this laundry list of healthcare providers, you have a higher duty to report things with specificity, like the name of the patient, the age, their medical treatment, their last known address, things like that. Those are things that a dentist or a healthcare practitioner would have from their own medical record. And so you need to provide more information when you report that as mandated by law, more than just what people are mandated. So if the covered entity in the exercise of professional judgment believes the disclosure is necessary to prevent serious harm to the individual or their other potential victims, or the individual is unable to agree because of incapacity, a law enforcement or other public official authorized to receive the report represents that the protected health information for which disclosure is sought is not intended to be used against the individual, and that an immediate enforcement activity that depends upon the disclosure would be materially and adversely affected by waiting until the individual is able to agree to the disclosure. You have to let the police know, and you can think about how situations where these might come out. This does require informing the individual. Further notice requirements exist, but this allows you under HIPAA to fulfill your mandate under state law. We also have health oversight activities. This is a big one for what I used to do. Apologize for a little bit of the fine print here, but you have permitted disclosures by a covered entity who may disclose protected health information to a health oversight agency for oversight activities authorized by law. What law? State law, including audits, civil, administrative, or criminal investigations, inspections, licensure or disciplinary actions, civil, administrative, or criminal proceedings or actions, or other activities necessary for appropriate oversight of the following: the healthcare system, government benefit programs for which health information is relevant to the beneficiary's eligibility. It also entitles entities subject to government regulatory programs for which health information is necessary for determining compliance with program standards. Are you getting paid as a dentist for root canals by performing root canals? If there are entities that are subject to civil rights laws for which health information is necessary for determining compliance, thinking of possible examples of that. For an exception to health oversight activities, for the purposes of these disclosures, a health oversight activity does not include an investigation or other activity in which the individual is the subject of the investigation activity, and such investigation or activity does not arise out of or is not directly related to the receipt of health care, a claim for public health benefits related to health, qualification for or receipt of public benefits or services when a patient's health is integral to the claim for public benefits or services. So these exceptions, let's say you have a labor violation. You're not paying your receptionist minimum wage. The labor standards people can come in and get records and things. Those are not health oversight activities. Those are general labor, occupational health and safety requirements that do not have anything to do with the receipt of health care, a claim for public benefits related to health, or the qualification for or receipt of public benefits or services when the health is integral to the claim for public benefits or services. So think about how there would be an exception in that kind of a context. How about disclosures for judicial and administrative proceedings? Again, that was bread and butter of what I used to do. Permitted disclosures where a covered entity may disclose protected health information in the course of any judicial or administrative proceeding in response to an order of a court or administrative tribunal, provided that the covered entity discloses only the protected health information expressly authorized by the order, or in response to a subpoena, discovery request, or other lawful process that is not accompanied by a court order if The covered entity receives satisfactory assurance, according to this section, from the party seeking the information that reasonable efforts have been made by such party to assure the individual who's the subject has been given notice, or that the given satisfactory assurances from the party seeking the information that reasonable efforts have been made to secure a qualified protective order that meets the requirements. Here's a little bit about how that works in practice. If you're a dentist and you're under investigation, you may have a complaint served upon you. Let's move back here. We'll stay on slide 24. Okay, thank you. You have a situation where a dentist is under investigation for doing a bad root canal. A patient complains. The dental police show up. The dental investigator shows up with a subpoena for that patient's records, and what with it? The patient who filed the complaint signed their rights away to the records to allow the state agency to receive them for purposes of carrying out the patient's complaint. That does not mean, however, that the exception is voided in its entirety, because state open records law would incorporate HIPAA by reference, and those matters, those patient medical records would maintain themselves confidentiality and would not be released to the public. So just because the state agency can get them, either with a release or with an administrative subpoena or both, doesn't mean that they are releasable to the world. They may still be releasable and not exempt from disclosure, but they're still confidential as to the rest of the world. Continuing now with disclosures for judicial and administrative proceedings, if the covered entity receives satisfactory assurances from the party seeking the protected health information, if the covered entity receives from a party a written statement and accompanying documentation demonstrating that the request has been made in good faith to provide written notice to the individual, either if their location is known, then by mail to the last known address. The notice includes sufficient information about the litigation or proceeding in which the protected health information is requested to permit the individual to raise an objection, and the time for that objection is passed. No objections were filed, or all objections were ruled on and resolved. So you do have some situations where there is that extra level of compliance and protection. More on law enforcement officials, if you have a covered entity who may disclose protected health information for a law enforcement purpose to a law enforcement official if the conditions of the following are met. There are permitted disclosures pursuant to process and otherwise required by law. A covered entity may disclose protected health information, or as required by law, including laws that require the reporting of certain types of wounds or other physical injuries. You have hospital emergency rooms and physicians that are required by law to provide information on gunshot wounds, and that information that is required is not subject to HIPAA confidentiality. Let's see now, we'll move on. We have compliance with, law enforcement officials have to follow in compliance with and limited by the relevant requirements of the court order or court-ordered warrant or a subpoena or summons issued by a judicial officer. The grand jury subpoena, an administrative request, including an administrative subpoena or summons, a civil or an authorized investigative demand or similar process by law, where the information sought is relevant and material to a legitimate law enforcement inquiry. The request is specific and limited in scope to the extent reasonably practicable in light of the purposes for which it's sought. De-identified information could not be used. There are permitted disclosures for name and address, date and place of birth, social security number, blood type, and such like that. So you have to follow these specific things. Permitted disclosures also include, and I hope we're going to get to this later, about how states serve requests for records, and we'll finish up with a slide on that. There is limited information. Let's make sure we go over this. Okay, we're on slide 28. Yes, slide 28, please. Limited information for identification and location purposes, except for disclosures required by law as a different part of this section. A covered entity may disclose protected health information in response to a law enforcement official's request for information for the purposes of identifying or locating a suspect, fugitive, material witness, or missing person. Remember, that's where I thought you should ask Is the person missing because you think I did it, that they're dead in a ditch somewhere, or you're trying to find that missing person that I had nothing to do with. I just happened to treat them at my office last week. You can disclose that information to law enforcement, the name and address, date and place of birth, social security number, ABO blood type, and RH factor, type of injuries, date and time of treatment, date and time of death if applicable, and a description of distinguishing physical characteristics such as height, weight, gender, race, hair, eye color, presence or absence of facial hair, beard or mustache, scars and tattoos. So think of all of the things that you might have as a doctor, as a physical therapist, as a healthcare provider. If you noted, well, they were here last week for treatment. They were perfectly fine last week. This was their height when they came into the office. This was their weight when they came into the office. Those kinds of things like that. Victims of a crime, you have a covered entity may disclose protected health information in response to a law enforcement official's request for such information about an individual who is or is suspected to be the victim of a crime. That is, we're trying to find the person dead in a ditch somewhere. Obviously, if you agree to it, you can disclose it. If you're unable to obtain the individual's agreement because of incapacity or other emergency circumstances, then law enforcement can get it if the law enforcement official represents that such information is needed to determine whether a violation of law by a person other than the victim has occurred, and such information is not intended to be used against the victim. That is, you're trying to help the victim. We think they're dead in a ditch somewhere, and we're not using this to go after them. We're using this to help and locate them. Also, if the law enforcement official represents that immediate law enforcement activity that depends upon the disclosure would be material and adversely affected by waiting until the individual is able to agree to the disclosure, again, you're not going to wait around to try to find that person who is maybe dead in a ditch. Is dead in a ditch. You don't have to go through the rigmarole of the time and effort of seeing that they are attempted to be contacted. Sorry, if you think the person is dead in a ditch somewhere, let me write them a letter and tell them that if they don't respond in 10 days, I'll go ahead and release this information. You also have the disclosure being in the best interest of the individual as determined by the covered entity and exercise of professional judgment. Remember, this is the question. Oh, did you think I'm responsible for the person being dead in a ditch somewhere? No, someone else did that. They were met at the hands of violence by someone, not you. Of course, the covered entity is going to think, this is really in their best interest to find them and track them down and get them located by law enforcement. What about dead people? Decedents. A covered entity may disclose protected health information about an individual who has died to law enforcement for the purposes of alerting law enforcement of the death of an individual if the covered entity has a suspicion that such death may have resulted from criminal conduct. So again, look at the standard here. If you're a dentist, you can disclose this if you have just nothing more than a suspicion that such death may have resulted from criminal conduct. What about a crime on the premises? A covered entity may disclose to a law enforcement official protected health information that the covered entity believes in good faith constitutes evidence of criminal conduct that occurred on the premises of the covered entity. We think the person got beaten while they were in the clinic recovering from their procedure. What about permitted disclosures for reporting crime in an emergency? A covered entity healthcare provider providing emergency care in response to a medical emergency other than such emergency on the premise of the covered healthcare provider may disclose protected health information to a law enforcement official if such disclosure appears necessary to alert law enforcement to the commission and nature of a crime, location of such a crime, or the victim of a crime, identity, description, and location of any alleged perpetrator of the crime. Use and disclosures about decedents, coroners, and medical examiners. The covered entity may disclose protected health information to a coroner or medical examiner for the purposes of identifying a deceased person, determining the cause of death, or other duties as authorized by law. Coroners and medical examiners do a lot of things. A covered entity that also performs the duties of a coroner or medical examiner may use protected information for the purposes. What if you're the local you're a local small town country doctor? You are the coroner in the county, and you are allowed to use that information. Funeral directors, a covered entity may disclose protected health information to funeral directors consistent with applicable law as necessary to carry out their duties with respect to the decedent. If necessary for funeral directors to carry out their duties, the covered entity may disclose protected health information prior to or in reasonable anticipation of the individual's death. So let's say you're a doctor, you're providing hospice services, you're a nurse providing hospice services, the patient is registered with hospice and they are dying of a disease, or maybe they have an HIV or AIDS status. You are allowed to, even before the person dies, to contact the funeral director and say, we'll notify you when this individual passes away, and by the way, they had a blood-borne disease, or this is their HIV or AIDS status. Please use universal precautions carefully. Also, standard kinds of information about the decedents, such as uses and disclosures for cadaveric organ, eye, or tissue donation purposes. How many of us have ever signed the back of our driver's license to give organs, eye, or tissue donation? A covered entity may use or disclose protected health information to organ procurement organization or other entities engaged in the procurement, banking, or transplantation of cadaveric organs, eyes, or tissues for the purpose of facilitating organ, eye, or tissue donation and transplantation. Trying to think of an example of how this may come about. Maybe I just went for my ophthalmologist for an eye checkup. Maybe there is or isn't something kind of wrong with my eyes. I mean, I do wear glasses after all. I'm killed in a car wreck. My family wants to donate my eyes and corneas. It could be something that someone would need to know in the organ procurement process about my last medical visit with my ophthalmologist, and the ophthalmologist can disclose cadaveric organ, eye, or tissue donation information if that is relevant. State licensure boards and agencies, regulation of persons who are healthcare professionals. We are kind of winding down, and I want to get into the home stretch, but this is a lot of what I like to talk about because it's what I did so much of. And, you know, many of these things are the subject of other various webinars and presentations that I've done. They could be standalone topics by themselves. State licensure boards and agencies, these regulate persons who are healthcare professionals. Sometimes they also regulate the place. So, for example, the Board of Pharmacy in states, the Board of Pharmacy will regulate the person who he or she is a pharmacist, a person who went to school and passed the test to be a pharmacist. But they also give a permit to the facility that is the pharmacy. That's why you see pharmacies and local grocery store chains where on Saturday night at 6 o'clock the grocery store is still open, but the grocery store pharmacy closes and a chain goes across and the pharmacy is locked up, allowing the grocery store to remain open, but the pharmacy itself closes. So you have the regulation of that place as a permitted place to operate a pharmacy. Does it have locks? Does it have a security? Blah, blah, blah. State laws vary, but if you are a healthcare professional, they usually give state law broad authority, such as a state board has the power to investigate complaints or suspected violations of this law, and they have the duty to notify proper law enforcement agencies and authorities. For the purposes of enforcing this particular chapter, this is Kentucky Revised Statute, Chapter 319, the board shall have the authority to administer oaths, receive evidence, interview persons, issue subpoenas, and require the production of books, papers, documents, or other evidence. People, think about what this law says. What else in the world could you possibly obtain that's not a book, paper, document, or other evidence? It seems like you can obtain about anything. I've had healthcare investigations that involve the propriety of a doctor-patient relationship where the investigator went with a subpoena and got hotel records because they were pretty sure there was a romantic and prohibited sexual relation going on between the doctor and patient, and that they had gone to a certain hotel together. So that would be a book, paper, document, or other evidence. Client authorization and releases are part of the complaint process. there are third-party exceptions. If a patient is complaining about his own root canal, of course they're going to sign a release for the root canal records. But sometimes you will have a third party make a complaint. It might be dentist number 2 who says, I treated this patient's totally botched root canal. They don't want to get involved, but I'm turning in the other dentist who did this. That dentist must have something going on. The patient doesn't want to get involved, but the authorities need to know. State agency administrative subpoenas can obtain paper and digital records, and a primer on how state agencies investigate. I think the most important thing for state agencies was establish a pattern and getting other records or the licensee's personnel file. Suppose you have a bad root canal case, a subpoena authorized by the state agency as mandated by state law fits that HIPAA exception we talked about earlier. And in fact, they probably have with the complaint a patient release signed with that. So like the barking dog chasing a pickup truck down the street, what does it do when it catches one? Here's the agency that is investigating, and they look and realize, yep, this was a pretty bad root canal. Sure enough, what do we do with it? I wonder if all the root canals this dentist did were bad or not. Let's go fishing and pull the last 20 root canals. Those are not going to be done with patient consent or time to object and notice. Paper and digital records can be obtained of, let the agency look at the last 30 records or 20 records of root canals. Establishing a pattern out of that batch of 20 or so was very, very important, because let me tell you, 3 or 4 or 4 or 5 bad root canal cases was so much more potent than just one bad root canal case. Anybody is entitled to have a bad day, perhaps, but if you've got a pattern of 3 or 4 or 5, it doesn't take much to do a pattern. And establishing a pattern is something that HIPAA is expressly going to allow the investigators to take advantage of, because you don't need notice to the individual, you don't need client consent. State agencies are governed by state open records laws and privacy exceptions that exist. So remember, just because the state agency has it doesn't mean that it's going to be disclosed to the world. There was a 1992 26-year-old Kentucky Supreme Court case that said the psychological and mental health records of a psychologist under investigation by the board were exactly the kind of thing that is private and of such a private nature that it would not be disclosed to the public, even if they were obtained and if it was necessary that they were part of an investigation. They're still confidential to the rest of the world. Regular investigations involving standard of care by necessity involve patient records and protected health information. I posit and ask, do you have a privacy interest in your root canal? Maybe not. Big deal. You know, you had a root canal and crown. But note that the medical histories of patients have the most private information: sexual history, past sexually transmitted diseases, current medications. Current medical records of current procedures may also be very confidentiality when they list current medications. I'm not embarrassed to say, and it's not very private to say I had a root canal 2 days ago, but I might not want my employer or my spouse to know that I got a 15-day supply of hydrocodone tablets because the root canal was awful and the nerve was split, and I'm really going to be in pain, and I don't want my doctor to know that or my employer to know, rather, that I'm taking prescription pain pills for this. The records retention of state agencies, again, how long do they keep the records? It was a pet peeve of mine in state government about that they left records around they didn't have any need for when that was a liability. I think that they may retain medical records to share with other state agencies for law enforcement purposes, but will likely never need those records again for their own purposes. That is, if you get a smattering of bad root canal cases that have been fraudulently billed to Medicaid, then those records may go over to the Medicaid department, and that's a kind of an example of a dental investigation that I gave. How can you comply as we round out third base here, and we're in the home stretch? Maybe I've mixed horse racing metaphors with baseball metaphors, but we're galloping down to the finish line. We've passed third base. We're in the home stretch. How can you comply where the request for protected health information when the patient is in trouble and law enforcement is involved, or when you are in trouble. Presentation of legitimate law enforcement demand to a healthcare professional, you need to see it in writing. Determine whether you are the focus of the inquiry. Does it matter? Well, you still have to comply. It's going to be a huge relief to you to let you know you're not the one who's the subject of this inquiry. Document, document, document. Do things in writing and save copies. Get law enforcement contact information for possible follow-up. Copy the written request or subpoena or search warrant. List the records that you've provided. Get a copy of whoever the detective or officer is of their business card so that you can follow if you need to. Consult a lawyer if you need to. Except in a true life or death emergency, you should have time to consult an attorney if you need to. Specifically, ask for an hour or a couple of hours to do so. Every healthcare practitioner should know a good lawyer to reach out to. Things can go wrong at each of the stages above, but if a detective is in your waiting room, you've looked at the written request for records, you're not sure whether you can provide it or not, or whether it meets this, you can tell the detective, I'll leave the record on the counter in sight, or I'll secure the record. Let me call my lawyer. I'm going to try to get a hold of her. Could you come back after lunch at 1 o'clock? Or I suspect to have an answer from my lawyer after 1 o'clock. There's no harm in asking and seeing if you can have a little bit of time should there be some need to arise that you need to consult counsel. So, in conclusion, I hope we've covered the basics of HIPAA requirements for patient records, some privacy exceptions with patient consent, some for law enforcement for civil, some for criminal, how the exceptions to HIPAA are applied by law enforcement agencies with an emphasis on state licensure boards, how they're going to get your records, or maybe a sampling of your records from a disgruntled patient, or maybe many patients who are not disgruntled, either when you are in trouble especially, or for those patient records if someone else is in trouble. We've learned a little bit about how you may comply with a request for protected health information when the patient is in trouble and when law enforcement is involved. Also, how to comply with a request when you are in trouble. We've skipped some case law today. I don't really have anything new that's from the courts on how this applies, and maybe we'll have some new information in the future and we can supplement this. So top takeaways as we round up to 58 going on 59 minutes. Top takeaways, HIPAA is not new, of course. You should all know the day-to-day basics of HIPAA, which should be routine. Document patient consent. Make sure you have a release in the file. That will be golden. And know your duty to report laws in your state. Don't confuse HIPAA as a roadblock to reporting suspected child abuse, neglect, or dependency, or otherwise complying with an administrative subpoena, because let me tell you, if you don't comply with an administrative subpoena, you will be hauled before that licensure board and you will be charged with noncompliance of an administrative subpoena, or maybe taken to court by the agency, and then you get your case in front of an expensive judge and lawyer time adds up. So understand the exceptions to HIPAA privacy for law enforcement purposes, whether for criminal matters or for civil matters. Review how state licensure boards and agencies work to investigate complaint. Don't confuse HIPAA or use HIPAA as a roadblock. Be prepared if law enforcement comes knocking the door, seeking information from you. Could be about your patient, could be about you, or could be about your professional license or the license of another professional.